Ladies and gentlemen, we will call this meeting of the Juvenile Justice Committee to order. I know that everyone has 9 different places to be, so we are going to get started. Representative Reeves, I believe you are here with us today on HB 912, and to confirm, we're working on LC 338213. Is that correct?
Yes.
Hold on. Try it now.
Yes, Mr. Chairman.
All right.
I think knock us down a little bit. We're going to get feedback. Perfect. Thank you, Mr. Chairman. This is my favorite bill of the session that I talked about at the last hearing. This is our second hearing on this, and it is the creation of a new short-term caregiver, essentially, that would allow a foster parent to be able to have somebody other than the de facto appointed persons to watch a foster child for up to 72 hours. This is going to be a great thing for foster parents, and if anyone has any questions, stand for them.
Thank you, sir. Are there any questions from the committee for the bill's author? I'm not going to try to guess. Number 11.
Yeah. Hey, how are you? Just kind of coming in. Thank you. So, I guess it's the technical term would be respite care. Is that correct? That we're working on right now.
This is obviously Director Rawlings would be.
Yes.
This actually qualifies as babysitting. So, a respite care is more of a technical term, and there is a bill, Senate bill, I believe, that addresses creating a respite care category.
Okay, so currently, there is no. How does someone get a babysitter?
So, if you are a vetted, certified, approved foster parent, right now you can, for a reasonable period of time, which has no clear definition in the law, let a person who is a reputable individual babysit a foster child. What this does is make sure that we put some strictures around that, expands it out to a sufficient amount of time, and make sure that those individuals who are really babysitters are not incorrectly categorized as those needing to be licensed and fingerprinted and regulated by the state.
Okay, so currently, if a foster parent needs to go away for the weekend, they have an emergency come up in their family, and something is this Saturday, how would they go about that process? Because what you're proposing is basically I would call my next door neighbor, and if they got a 18-year-old, they could watch them for me. But that's what this bill proposes. What is the current process now?
Sure, that's basically the current process now, unless it's for too many times, and then the problem is, especially with our CPA foster parents who are regulated by the residential child care licensing, if you do it too often, then it becomes a person who needs to be certified as a foster parent. But let me give you a good idea of how this came down last week. I was down at the Adoptive and Foster Parent Association of Georgia, and when I brought this bill up, I got a standing ovation just about on it because everybody was clapping. But the interesting thing was that the head of the National Foster Parent Association and the head of the Alabama Foster Parent Association asked me, why don't y'all just do this now? And I said the dilemma we run into is that we have 2 different systems of regulating foster care in Georgia. We have our de facto foster parents, and then we have our private agency foster parents, and private agency foster parents are regulated by residential child care licensing. To make sure that we're all on the same page and that we're all operating from the federally mandated reasonable and prudent parent standard, we needed to put some language in the bill that says this is what you can do, this is the extent to which you can have a person as a babysitter without making that person go through all of the certification and training and vetting, et cetera. But again, what they left me the impression with, and I think what we're trying to do here, is that when we have individuals that we have qualified as foster parents, whether they are de facto foster parents or with a private agency, a private nonprofit, Methodist Children's Home or Faith Bridge or Bloom or whatever it may be, that we are making sure that that we are trusting those foster parents to make good decisions about a babysitter, that we're giving those folks enough leeway to have a regular babysitter who can actually get to know the child, as opposed to having a bunch of rotating babysitters because they can't use the same person on a regular basis. Mm-hmm. So I don't know about you, but when I was a child, I fortunately had the same person to care for me when my parents couldn't care for me all the time, and we developed a wonderful relationship, and I loved that lady till the day she died. But I can imagine that if you have a situation in which, to avoid regulatory oversight, you're having to get a different babysitter every time, not knowing maybe even going outside of your circle to find someone, as opposed to finding someone that's in your neighborhood, in your church, for example, in your mosque, your synagogue, and trusting that person to be your regular babysitter. That's what we're trying to do.
Okay, and follow-up question. I guess my concern is not, and I think I brought this up before, is not the fact that we want to do this. It's the fact that we're trusting an 18-year-old. Like you, I went back to my community this weekend, and without pretty much everybody in the room looked at me and said, "An 18-year-old, are you serious?" They said the reason that we might be doing this is because we don't properly fund care for people to go and have somebody that can be there for them. So I'm just going by what I hear in my district. And you mentioned having a kid or being a child. I have a child, and we don't go away on the weekend. A babysitter is somebody when we have to go to a meeting at night and we leave them. But leaving someone for 2 to 3 days is not a babysitter. That's actually a caregiver that you would have a little bit more of I'm okay with a 14-year-old or 15-year-old or 16-year-old watching my young child, but I would not leave them with them for 3 days. So my concern is the fact that if it wasn't for the fact that I've been on this committee long enough to hear calls where children have died in care because of concerns that we fix later, I wouldn't be concerned. But what I'm feeling right now is that we are saying that it's not a big deal to give an 18-year-old. We got to trust people. I just asked DFACS how many foster care parents have been arrested. They can't give me that number. And I was also told that they cannot give me the number of people that are in care of others because they don't necessarily track that. So, it's not what we're trying to do. It's the fact that we're giving to an 18-year-old. So, I mean, I may be in the minority on that, but I just wanted to voice my concerns as we move forward, so that if I do get that phone call from 2 years from now, I will not, I will feel like at least I did my part.
I appreciate it. I respect your position, and I hope to God you never get that phone call. If you do, you can point the finger right at me, and I'll take the responsibility for it. Thank you.
Number 28.
Chairman. Thank you, Mr. Chairman. I feel like we've talked about this bill. We've heard it, had a lot of question before, so I stand ready to make a motion at the appropriate time, Mr. Chair, when you deem that.
Yes, sir. I've got one more question, then we'll entertain that motion. Number 16.
I just wanted to make a comment. I like this bill because I think about the foster kids who want to go to a sleepover. If this doesn't pass, everyone has to get a background check, which stigmatizes the child. It's really nobody's business if this child's in foster care. But if there's a sleepover that she wants to go to, and you have to give everybody, you have to tell them that you're in foster care to do that. So I think, with reason, this is a move in the right direction.
Thank you, Representative.
Mr. Chairman, and on that same note, if y'all recall the committee, there was a lady last week that actually testified on the other adoption bill that I have, but she sat through the first hearing on this bill, and I didn't realize this, but she sent me an email, and they foster, and she talked about a time in 2015 when they went out of town, and she had 2 biological kids and a foster kid. And I'm going to skip some of the email, but when it came time to leave, I dropped off our biological kids at my friend's house with their children, and then had to take my foster son to a stranger's house because that was what the policy required. Poor guy, as we were driving away, he's asking me, why can't I stay with Eddie and Debbie?
Chair, let's see, number 28, recognize Chairman Cantrell.
I move to pass.
We have a motion and a second do pass. Is there any further discussion? Seeing none, all those in favor say aye.
Aye.
Any opposed? No. Motion carries. Thank you, Representative Reeves.
Thank you, Mr. Chairman.
Next up, I believe, will be Representative Gravely, House Bill 971.
You hear me okay? Get to the mic, Pam, is that what you'd like me to do?
Yeah, we really do need a microphone.
Oh, come on.
It's right here, Micah.
There it is.
Micah,
Here.
right here. Thank you, sir.
You're welcome. Oh, boy. Mr. Chairman, members of the committee, thank you so much. I know everyone has other places they're obligated to be, and I appreciate you being here, so thank you. House Bill 971 is a collection of minor but necessary changes that have arisen in the years following the comprehensive revision to the Juvenile Code, passed in 2013 in House Bill 242. The proposals contained within the bill are neither major policy shifts nor new programs. But these tweaks are important to the operation of our child welfare and juvenile justice systems. The bill is jointly requested by the Department of Juvenile Justice and the Division of Family and Child Services, and a representative from each agency will address these provisions centrally related to their work. The bill also addresses requests made by the Council of Juvenile Court Judges. The entirety of the bill has been vetted through the Office of the Governor, and its separate provisions were developed by affected and interested stakeholders throughout the juvenile justice and child welfare systems, including Georgia court-appointed special advocates, the Supreme Court Committee on Justice for Children, and the Barton Child Law and Policy Center. I have with me today Cindy Wang, General Counsel for DJJ, and Chris Hempfling, General Counsel and Deputy Division Director of DFACS. They're with me to help present their particular sections of the bill. And if, Mr. Chairman, if you will permit, I would like for Ms. Wang, who will present sections 1, 2, and 13. If you don't mind, we could start with
By all means,
Mrs.
yes, sir.
Wang's presentation.
Please proceed. Thank you for being here.
Thank you. If everyone could hear me.
Oh, no. Here you go.
Hello. Regarding section 1, we're just clarifying the definition for a DJJ staff member acting as a juvenile court intake officer, and that's going to be amending OCGA 1511-2, provision 41. And that's just to make sure that it's very clear that we're handling the delinquency proceedings and children in need of services proceedings. For section 2, that's mandating a initial training of 8 hours and then 2 hours annual training thereafter. And it was just follow-up language to House Bill 472 that passed last year. And I don't know if anyone has any questions. Okay.
Any questions thus far from the committee? Seeing none, please keep going.
Carried on within section 1 is a cleanup of 472 regarding temporary alternatives to foster care. This is an initiative, part of the rollout of the Family First Prevention and Services Act. That is a federal law that Georgia is beginning to implement. It was really just a typographical error and lines like 20 there. Section 3, this is clarifying the authority authorized to juvenile courts. Last year, also in relation to 472, we allowed juvenile courts to issue a temporary alternative to foster care. There's been some disagreement as far as within the juvenile courts as far as whether or not what was authorized ties back to 1511-29, which is the protective order powers of the juvenile court. This is making that direct connection and link between those two statutes in order to make sure that juvenile courts do have that authority and are authorized in order to be able to do it. Section 4, Representative Gravely mentioned the collaboration with the court-appointed special advocates. There are several sections within this that talk about the hearsay element. At every dependency hearing, CASAs throughout the entire state of Georgia, they have a written CASA report that they submit to juvenile courts that talk about their involvement, their observations of the child, where they see the case should head and the best interest for that child within the case. There have been instances within Georgia where a court has not considered the very important work of CASAs within that report because of hearsay elements. During any dependency hearing, at the adjudication hearing and a termination of parental rights hearing, you have the hearsay and the evidentiary code that plays into effect there, but there are a number of hearings that happen after an adjudication and after a termination of parental rights. And what this is doing is making sure juvenile courts are aware and understand that they are always allowed to hear hearsay evidence at any non-trial like setting. That way it will allow all those CASA reports to come in order for the judge to make the best determination about what is really in that child's best interest for that proceeding. Section 6 further talks about hearsay and allowing that to occur. Section 7 and 8, same thing. Section 9 is, this is an administrative request that we're making to the body today. Several years ago, there was a piece of legislation that passed that said every 60 days, the department is required to make an administrative 4E determination for children that are 18 to 20 years old. In order for us to make an administrative 4E determination, that process can actually take several weeks or several months. Federal law only requires us to make a 4E determination once every 12 months. So what this is doing is aligning the state law with federal law in order for us to be able to maximize those funds within the code. What else did I miss? Did I miss anything else? Any other questions?
My apologies.
That's right.
Appears to be no questions from the committee. Committee will stand at ease for 1 minute, please. Number 16, Representative.
Thank you, Mr. Chair. I have a question about the 4E. So my thought is they were doing it every 60 days instead of the 12 months that's required by federal law to keep up with that requirement, correct?
Right now, I believe this committee 2 years ago passed a piece of legislation that allows us, the agency, to begin to pull down 4E funds for those 18 to 20-year-olds. The Chafee Act is the federal law that allows us to pull down those funds. That bill actually goes into effect July 1st of 2020. So we actually have not started to pull down any of those federal funds for those youth at this time. So that's why this request was made in order to be able to be in preparation for when we actually do start to pull down those federal funds.
But if they lose 4E eligibility at some point during that 12 months, is that money we have to repay?
No.
Okay.
And Mr. Chairman, I apologize. I would like to see if Ms. Wang didn't have an opportunity to present sections 13 in case the committee had any questions about that one.
That'll
Would she
be
be
just
permitted
fine.
at this time? Okay.
Section 13 just allows the department to have access to the information, the Child Abuse Registry, for employment purposes. Currently, we rely on self-reporting or reports from the residential treatment facilities.
Any questions from the committee regarding section 13?
Okay.
Seeing none.
Mr. Chairman, if there are no questions from the committee members, I understand that we're in the posture of a hearing today. And if the committee members have any questions, I know that Mr. Hempfling or Mrs. Wang would be available to answer any of those questions, but the bill is simply a department cleanup bill, just a few things that we just needed to adjust. No major policy shifts, and would hopefully, I think there may be a committee rescheduled later this week possibly for the bill to possibly be voted at that time, and we'll adhere to the committee's schedule.
Thank you very much. Are there any further questions for Representative or his guest? Seeing none. Representative, thank you for being here.
Thank you so much.
Thank you. Committee, we will look at House Bill 993 from Chair Lady Dempsey.
Thank you. Thank you. I appreciate it, Mr. Chairman and
Yes, ma'am.
members of the committee.
Floor is yours.
Okay, so House Bill 993 is a pretty straightforward bill, actually. It's pretty simple, also dealing with some of the challenges that we face for Georgia's children right now. It will allow access to vital records, reports, and data in a timely fashion. If y'all will recall, last year we did a bill involving data. This kind of takes that to the next step as well. Throughout the bill, you'll see that the word shall is used, so it is requiring these actions to take place for the Division of Family and Children's Services to receive that information when there is a report of abuse or neglect concerning a child or his or her parents or siblings, particularly pertaining to records related to birth or death, fetal death, or putative father registry. It also allows not only for the access of that data in a timely manner, but also for the Department of Public Health and the Division of Family and Children's Services with Department of Human Services to develop the policies, procedures, and schedules and enter into agreements that will require this and also allow for compliance with all of the federal stipulations that are regarded and issues regarding the privacy and very sensitive information here, but very important to get in a quick and true fashion. And that is simply what it will do. I do have Director Rawlings here for any questions or committee members.
Any questions from members of the committee for Chair Lady Dempsey or Director Rawlings? Letting him get settled. Any questions? Okay. Well, I'm just making sure. Chair Lady Dempsey, once again, we're in a posture of a hearing on this bill today and look forward to scheduling additional meetings of this committee as soon as possible. So since there are no questions from the committee, we thank you very much.
Thank you.
Thank
Members
you.
of the committee, I am working on one last bill on our potential agenda. Representative Setzler is in another meeting, so if we could just stand at ease for 2 minutes and let me get confirmation on his availability.